This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about a domestic abuse exception to the intentional act exclusion contained in almost every insurance policy, and why pouring gasoline on an ex-wife and house and setting them both on fire still allows her to recover for loss to property, even though there was no question that the fire was an intentional act, and it was certainly not nice to set an ex-wife on fire and burn down the house. Brenda Welch owned a home in Lynnwood, Washington, and the couple lived there throughout their marriage. The home was subject to a mortgage held by CitiMortgage Inc. During their marriage, Welch and her ex-husband, David Morgan, had one child together, KW. On May 21, 2014, the court finalized their divorce, awarding Morgan the family home and requiring that she either sell the property or refinance the debts into his sole name within 3 years of February 5, 2014. After the divorce, Welch met a new partner and moved in with him. Still, Welch and Morgan shared custody of KW, and their parenting plan called for joint decision-making. On November 16 of 2014, Welch went to the Lynnwood home at a prearranged time to pick up KW from Morgan's care. But KW was not there. Instead, Morgan attacked Welch, beat her unconscious, doused her in gasoline, and set her and the house on fire. Welch survived but suffered significant mental and physical injuries. The fire destroyed the house. In Brenda Welch v. Pemco Mutual Insurance Company, the Court of Appeals of Washington on September 3, 2024, dealt with the issue where Pemco Mutual Insurance Company denied Brenda Welch insurance coverage for loss incurred after her ex-husbands assaulted her and burned down their former marital home. Pemco determined that the loss was intentional and rejected Welch's argument that the loss arose from an act of domestic abuse, an exception to the intentional loss exclusion. Welch sued Pemco. The trial court dismissed Welch's claims at summary judgment. At the time of the fire, Morgan had not yet sold or refinanced the Lynnwood home, so the deed still named Welch as an owner and obligor on the mortgage. Welch and Morgan held an all-risk insurance policy on the property through Pemco. The policy named both Welch and Morgan as insureds, and it also listed CitiMortgage as a mortgagee. The Pemco policy excluded coverage for any loss arising out of any act committed by or at the direction of an insured with the intent to cause a loss. But it also has an exception to that intentional loss exclusion for acts of domestic abuse, which provides that the exclusion will not apply to deny an insured's claim for an otherwise covered property loss if such loss is caused by an act of domestic abuse by another insured under the policy. A jury found Morgan guilty of attempted first-degree murder, domestic violence, and first-degree arson domestic violence. The trial court sentenced him to 260 months in prison. Welch then sued Morgan for her injuries from the assault and got a large verdict. Morgan did not respond, and the trial court entered a default order and judgment against Morgan for $5.06 million. Welch also claimed coverage under the Pemco policy, and CitiMortgage claimed coverage for the outstanding balance on the mortgage. Pemco estimated that the repair replacement cost of the damage to the home was $463,732.82. In June of 2016, Pemco found coverage for CitiMortgage, but PEMCO denied Welch's claim. It explained that the intentional loss provision precludes coverage not only to the arsonist but to the insured, including Ms. Welch. Welch sued PEMCO, and the trial court granted in part and denied in part PEMCO's motion. The court denied PEMCO's motion on the applicability of the domestic abuse exception. It concluded that Welch and Morgan were not family, so the domestic abuse exception to the intentional loss exclusion did not apply. The Court of Appeals, however, must construe insurance policies as the average person purchasing insurance would. That is, give the language a fair, reasonable, and sensible construction. And the Court of Appeal gives undefined terms their plain, ordinary, and popular meaning. In addition, the Court of Appeals may turn to the dictionary definition of an undefined term to determine its plain meaning. Welch's policy excludes coverage for intentional loss unless an act of domestic abuse by another insured under the policy causes the loss. The PEMCO policy language parallels former RCW 48.18.550. That statute was in effect when Morgan tried to kill Welch and burn down the house. The statute requires insurers to cover intentional loss caused by an act of domestic abuse by another insured under the policy. Modern editions of the dictionary define family as the basic unit in society traditionally consisting of two parents rearing their children, or a group consisting of parents and their children. Welch meets these definitions because she and Morgan were raising KW under a parenting plan that granted them shared custody and called for joint decision-making. As such, they were two parents rearing the child and fit within this modern definition of family. An average person purchasing insurance would understand the family term under the more modern definition, and because Welch and Morgan share a child that they were raising together, Welch is part of a family under the policy's domestic abuse exception to the intentional loss exclusion. Therefore, the trial court erred by granting summary judgment for PEMCO and refusing to grant partial summary judgment for Welch. Therefore, summary judgment for PEMCO was reversed, and the trial court was directed to enter partial summary judgment for Welch for breach of contract. In my opinion, the exception to the exclusion was found to apply because although divorced and no longer married, since Welch and Morgan still had joint custody of a child, they fit a dictionary definition of family, sufficient to allow the court to allow Ms. Welch to recover her share of the insurance recovery over that paid to the mortgagee. Her ex-husband gets nothing, and he will probably be unable to pay any of the $5 million judgment against her because he will be in jail for a long, long time, and his intentional act is clearly excluded under the liability portion of the insurance policy. This video was adapted from my blog Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll have access to the more than 4,850 blog postings. You can also subscribe to these videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble or the like button on YouTube. And please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication, where I post articles on a regular basis about insurance topics. Thank you for your attention.